this time lays out House Bill 1499 and recognizes Representative Campos to explain it.
Good afternoon, Chairman Dutton and Vice Chair Lujan and committee members. Thank you for the opportunity to lay out House Bill 1499, duties of court-appointed ad litems, attorney ad litems, and attorneys in certain suit affecting and parent-child relationship. During the interim, concerns were raised from DFPS management, placement, and indigent parents over poor representation from attorneys ad litems. For example, court-appointed attorneys met at last as the day of the scheduled hearing. My staff and I witnessed attorneys make requests to the court without even meeting with the child they represent. In 2018, the Children's Commission did a study of representation in CPS cases, and the study found that despite surveyed lawyers saying they provided high-quality representation, the parents and caseworkers did not agree. In that study, 35% of the children in care who were surveyed stated their attorney never met with them before the court hearing. HB 1499 provides a more defined timeline of when court-appointed attorneys and advocates must consult with their clients and uphold the Texas Family Code's definition listed in Section 107.001 of undivided loyalty and competent representation, because they are appointed to represent the best interests of the child. Specifically, attorneys and advocates must consult with their client not later than 7 days after the appointment, must consult at least 72 hours prior to each scheduled hearing, and visit the child at least once each month to properly monitor the child's safety and well-being. A pending committee substitute will allow outside sources to the case be interviewed by the attorneys within 15 calendar days, and include the requirement that both types of ad litems must ensure their clients, depending on the age, have their state or federal documentation. Substituted judgment under Section 107.008 will be amended to only apply to children with IDD, because stakeholders have indicated this type of representation is being seriously abused. During the interim, I did a lot of work with CPS, and so this is where my bill is coming from. I had some parents and DFPS, management that I spoke with, because I do my best to try to work it with as many as possible to collaborate to make things better for our children. And so this is where my bill stems from, and I'm here if you have any questions, and I reserve the right to close.
All right. Representative Campos, let's see if there are any questions. I don't believe so, and so we will give you the right to close. We will start the public testimony now. Chair calls Jeffrey Morgan, again representing himself and testifying neutrally on House Bill 1499.
Thank you. My name is Jeffrey Morgan. I am testifying for myself. I'm testifying on the bill. Representative Campos, I think that you brought some very good points up. What I have seen, what I've heard, and for those who don't know, I've been looking at this family court stuff and what's taking place in our Texas family courts for probably 10 years. I've got about 2,100 videos on my YouTube channel, that's what these QRs are to. If you put them in your phone, you can see them. I've talked with people all over the place, and regarding some of the stuff that takes place. A couple of videos that I put down here is that the guardian ad litem, the ad litems and the amicus attorneys actually have the expertise to make sound recommendations, and basically the idea that ad litems sometimes think that they can rearrange families. But those are the two videos that I had down there. But the things that I wanted to mention here just in my testimony real quickly is that an ad litem is always a stranger to the child. And even though the ad litem is supposed to be representing the child, still is a stranger. Maybe sees a child for a couple of hours before representing the child, or as you mentioned, maybe the day of the representation or whatever. And it's been a lot of very ineffective representation of children. I also think that, so I think what you're getting at is that there's some type of corruption, some type of mismanagement, fraud, or whatever in the system as it is right now. The two other things I'd like to see is I'd love to see the ad litem fees be capped, because right now the ad litems can charge whatever they want, whatever they call reasonable. Is that not true, Representative Wu? Okay, if it's not true, that's fine. I was unaware of that then. So, and the other thing is that, and I apologize if that's the case, maybe I'm confusing two things, but the other thing is the best interest of the child. The guardian ad litem, or the ad litem, is supposed to be representing the best interest of the child. No one yet has defined what that means. That is a very nebulous term. Representative Leach said it's paying money out. There's always something that we say in the best interest of the child. There is no objective meaning to that. And even the experts who deal with this tell you there is no objective meaning to that. I talked with a judge who said it is a subjective term. So the best interest of the child for one ad litem might be completely different than what it is for another ad litem. If you look at KP0241, the Attorney General Ken Paxson wrote, fit and willing parents are supposed to be presumed to act in the best interest of the children. Anyway, that's all I had to say about that. I'm just testifying on the bill. I appreciate, Representative Campos, that you brought out some of these issues, because I think that they are big issues, especially in our courts today, our family courts.
All right. Any questions for Mr. Morgan, members? Not hearing any. Thank you, Mr. Morgan,
Thank you so
for
much.
being here. Thank you for your testimony. Chair calls Taryn Champagne.
Good afternoon. My name is Terrence Champagne, and I am testifying in support of this bill. Two big thumbs up on this bill. While I may find that court-appointed guardians ad litem, attorneys ad litem, or amicus attorneys may not necessarily be representative of what is in the best interest of the child, I find this bill to be a great bill, and that it removes vague language in the family code and inserts specific timelines in, so as to ensure that there are measurable timeframes to ensure adequate delivery of services. This is much needed, and perhaps in addition to these timelines, there should be some sort of performance metrics available if they fail to meet these timelines as outlined in the family code in this bill. And that is all I have to testify on. Any questions? Thank you very much.
All right. Thank you, Mr. Champagne. Thank you for your testimony. I guess there are no questions. The chair calls Carlos Damon.
Hello, Carlos. What other information do you need from me, Mr. Nutton?
Please give us I'll say this again for you. Every time you come up here, you have to start by giving us your name first, who you represent, and your position on the bill. Okay?
The position on the bill is
Yeah, wait, stop. You have it?
Carlos,
Okay. Carlos what?
the man.
Okay, thank you.
And
Your
I am in
position on the
favor
bill,
I'm in favor of this bill.
okay, and you're testifying for yourself.
That's correct.
Well, our computer says you were testifying neutrally.
Actually, I'd like to keep it a neutral.
You don't want to change it
No.
to, okay.
It's neutral. One thing that I like to have in that is just some. Well, part of the requisites are the guardian ad litem coming into this adjudication for the kid. So I don't see any prerequisites for the guardian ad litem. What kind of certifications do they have other than just a card? So if they have some sort of expertise, I'd like to say if they've had any type of additional training hours that makes them a little bit more better than the other one, it's down the street. That's the only thing I'd like for it to be added.
Any questions of Mr. Damon? I think Representative Wu has a question.
Yes, sir.
I can't speak for every county, but in my county, it's you pass law school, you pass the bar exam, and then you are have at least 15 hours of CPS-based training every year in CLE, and also that you qualify under the judge's requirements. for the court to be appointed as a guardian, as an attorney ad litem.
Thank you.
All right. Any further questions of Mr. Damon, members? Not hearing any. Thank you for being here. Thank you for your testimony. Chair calls Julia Hatcher.
Chair Dutton, committee members, my name's Julia Hatcher. I'm an attorney in Galveston. I'm also president of the Texas Association of Family Defense Attorneys. We're a statewide organization of attorneys representing parents and children in cases involving CPS. We are strongly in favor of this bill. I can also tell you that I actually sit on the Legal Representation Committee of the Children's Commission, and so I was intimately involved with the report that came out in 2018. And that is one of the reasons why TAFTA was founded, to help train attorneys to get better in the courtroom advocating for their clients. One of the biggest problems with attorneys right now, attorney ad litems, that is outlined in that report, is that they're not listening to their clients. And as attorneys, we're all supposed to do what our clients want us to do. And that is why I'm so glad that Representative Campos wrote in the section deleting substituted judgment. The ABA model rules for representing children do not include substituted judgment. Several states in our country do not include substituted judgment. And it's become apparent in Texas that it has become very abused and misused by attorneys who don't want to listen to their clients and just do what they think is in the children's best interest when that's not their job. That's the job of the guardian ad litem. It's also become a problem across the state with attorneys not meeting their clients prior to the adversary hearing or not visiting their clients before any hearing. And so we're glad that these timelines are put into place to require that, to make that to happen. Other than that, like I said, we're strongly in support of the bill. And if you have any questions, I'd be happy to answer them.
All right. Any questions of Ms. Hatcher, members? Not hearing any. Thank you, Ms. Hatcher, for being here. Thank you for your testimony. Come on. Come on, give me the whole list. The chair calls Anton Golokov. He's not here. He was testifying for himself and neutral on the bill. Brandon Johnson, the chair calls Brandon Johnson.
I'm Brandon Johnson, testifying for myself, and I'd like to change it from neutral to strongly for the bill.
So you're okay with us doing that, changing it?
Yes, sir.
Show you're for the bill as opposed to neutral. Okay,
Yes, sir.
we've done it.
Yes, I appreciated hearing from Representative Campos on this bill. Just putting the timeline, the deadlines on this for government agents or these items to perform is a good thing. And then it makes them accountable, just having them accountable for meeting with the client and all that stuff, because we do see this in a lot of these court cases. And one of those is, 2/3 of the docket in our courts are taken up by family law cases. And, it could be possible that, as I've stated last time I was up here, there's a lot of overlap. So I think it could be that these items are overworked and they get behind and lackadaisical. So hopefully they can come next year and say, look, if y'all will lighten our load by passing the equal shared parenting, I'm going to plug that for you, Representative Wu, because that will lighten the load and get some of the controversy outside of the courts. Thank you, Representative Campos.
All right, thank you. Any questions of Mr. Johnson, members? Not hearing any, thank you. Chair calls Aaron Robb.
Good afternoon, Chairman Dutton, members of the committee. I'm Dr. Aaron Robb. I'm here on House Bill 1449. I'm neutral on the bill. To give you a little bit of my background to start with, I have a PhD in social work. My area of research is the intersection of mental health and the law. I'm a former CPS worker, and I'm in private practice where I focus on high conflict family court cases. I've seen the kinds of things that this bill is designed to prevent go on since I was a caseworker in the late 90s. Attorneys who don't show up until minutes before the hearing to meet their clients. That's a real problem. But unfortunately, the scope of the bill is broader than those attorneys. By including guardian ad litem, which I've been a GAL as a volunteer for CASA, I've been a GAL as a privately appointed person in difficult cases involving severe mental health issues for families. And often in those kind of cases, when you look at the timeframes under 107.002B in the proposed bill, we don't even get the orders into our office within the first 7 days of them being signed. There are some easy fixes to this. There are some easy ways to identify cases involving the department versus private cases. I think there are some real needs. This has been going on my entire career, that there are some real needs to address these issues, and I appreciate that the sponsor has done that. All in all, the other thing is, what are the parents able to do? I deal with a lot of parents who cannot drop everything to go meet with a guardian ad litem within those first 7 days after appointment. Often those 7 days after appointment are coming after a 14-day adversarial hearing where everyone is scrambling to set up services to hopefully not lose your job as you lose your children into a state care system. And so there are a lot of struggles that go on that this may actually burden parents inadvertently. It's an unintended consequence as, again, we try to fix a real problem. And the last piece of that is there is no enforcement mechanism here. We can say, see your kids within 7 days of getting appointed, or we're going to tell you you should see your kids in 7 days of getting appointed, just like for the last 30 years we've said, see them in a reasonable time frame. No one has ever argued that hours before a hearing is a reasonable time frame, yet it is the common practice. I'd encourage you to have some form of action involved in this as you separate out the duties of the attorneys versus other kinds of GALs, and thank you for your time.
Thank you, Dr. Robb. Members, any questions? Thank you. Okay. Is there anyone else who wishes to testify on or for or against HB 1499? If not, Representative Campos, close.
Again, thank you, members. HB 1499 provides timeless for a timeline for attorneys and advocates to work together to get the support that they need. Families and children will have a standard of representation they should expect. With that, I respectfully ask for your support. Thank you, and I close.
All right. Thank you. Representative Wu?
Thank you, and I really appreciate this legislation. I know this is an important part of CPS cases, but I'm happy to work with you and talk with some through some of the issues, and I think we can make this work. But I just want to use this opportunity to say, I think a lot of this issue is not necessarily what requirements are put onto the parties involved in a CPS case, but is that there's no enforcement, right? So, like in my practice area, judges are very clear about what the expectations are. Attorneys, especially if they're representing children, not only submit written notice that they've done their visits, and they, like when I do it, I describe when I did it, what the situation was, what I viewed. Sometimes if there's a cute picture I can attach with it, I'll attach a cute picture with it. Right. But if we put more rules in, but we still have courts that don't enforce those rules and don't care, then adding more rules doesn't do anything. Right. And I'm happy to work with you on this, and we want to make sure it's something that actually is manageable.
Yeah, no, absolutely. And again, this stems from the work that I did this interim.
Absolutely.
And so I
appreciate your work on that. That was really important stuff.
Thank you so much.
Thank you.
I'll open to working with you in any way possible to make things better.
Thank you, Representative Campos. There's no objection. HB 1499 will be left pending.
Thank you.
Thank you.